Hello everyone and welcome back. In this video I'm going to talk to you about the Baker Act, and specifically if the Baker Act facility is telling you that your loved one can leave but only to go into one of their programs, either some type of residential program or some type of outpatient program. If they're telling you that as a condition of release, I'm sorry, but you are not being told the truth. In fact, you're being coerced and you're having your pocket picked. Now, whether or not the insurance is going to cover that is a different story. But if your loved one is appropriate for release, then the Baker facility has no business telling you that they have to go to their program, whether it's residential or outpatient. It's just a total shakedown. But we had a call today from a family. Their loved one was Baker acted, and the facility said, well, she needs another 30 days of treatment. And what we're recommending is that you allow us to transfer her from this locked facility to another program that we have. It's like a residential facility. She'd have to stay there. And you know, the family called us and I said, this is just a shakedown. This is an absolute utter shakedown. And if you want to be the ones to make the determination as to where your loved one receives services, we need to go to court. Because if she even met criteria, apparently she no longer does. And if she's appropriate to be transferred to a quote residential facility, then she should be choosing where she goes. Or if you have that authority, you should be choosing that for her, but not the state of Florida. And remember, when someone is Baker acted, they become a temporary ward of the state, and the state becomes their new guardian, which means that the people that work at the Baker facility, they get to make the decisions regarding that person's medical and mental health care. So if you are encountering this where the facility says they can leave, but then you know you're being shaken down and you should take immediate action to secure your loved one's release. And even if the detention was legal, even if they met criteria, you still have the ability and the option to find somewhere else other than the crummy state facility they're being locked down in that's going to take care of them. But in order for that to happen, you have to be willing to enforce their rights. And that means you got to file something. You need a lawyer to do that. You can't represent your loved one in court unless you're a lawyer. And so if you've encountered that, we need to talk. And if you're frankly willing to allow the facility to take that action, then don't be surprised when they go and file a petition with the court after all this is done and tell the judge they need more time. Because that's invariably what happens with facilities. They like to move the goalposts. They like to lie to people, and they don't take care of people. It's as simple as that. And having had my own family member Baker acted, I think I speak from a place of personal experience. But our office is also represented, I think, close to 700 other families. So if you're encountering this, we'd like to talk to you. And with that said, I would really appreciate a thumbs up. Please subscribe to the channel. I'll see you in the next video. Take care. Bye-bye.